In view of the above discussion, I am of the opinion that even if the notice is not sent to the members by registered post, the meeting cannot be held to have been illegally convened. The fourth respondent had come forward to file counter affidavit and has made his best efforts to justify his promotion to the post of deputy director, stating therein that since the post of medical officer cadre was abolished and it was restructured by creating a post of deputy director. There were two posts of deputy director from engineering services for the reason that after abolition of medical officer cadre, there was no occasion to keep alive the post of deputy director from medical services. We therefore hold that 15% interest in respect of unpaid amount of fourth installment is to be computed on compound basis and has to be paid by respondents in order to get sale deed executed by appellants. In the agreement, it was contemplated that entire payment shall be made by 15/6/1981, but for the reasons stated above, that is, non-availability of clearance certificate from sealing department, etc., and thereafter involvement of parties in litigation, last installment has remained unpaid till date. We therefore hold that same rate of interest on compound basis will have to be paid by respondents to appellant on unpaid amount of installment. The 1994 Act, being a special law, would override the general provisions of the 2006 Act as amended in 2012. The statement of objects and reasons as well as the legislative debates leave no room for doubt that the 2012 Amending Act clearly intends to preserve the status of the university and also the extent of reservation in favor of scheduled castes, scheduled tribes, as was existing prior to the 2006 Act. Petitioner's case of contractual employment has been disbelieved for cogent reasons. The non-production of attendance register and wages register was also material. It is settled principle of law that the evidence of interested or related witnesses should be considered with caution, and until and unless it is found to be trustworthy, the convictions of accused on the basis of evidence of related or interested witness is not justified. In view of the discussions made above and considering the unnatural conduct of PW1 and PW2, I am of the considered view that they are not proved to be eyewitnesses of the incident of enticing away victim by accused appellant in presence of co-accused persons or otherwise, and their testimony is neither reliable nor trustworthy. From the perusal of agreement, it is further evident that the appellant has secured liability on his part by incorporating an indemnity clause in respect of the negligent acts of the driver playing the vehicle. Thus, it is open to the appellant to claim from the owner any loss that would arise out of negligent acts of the driver. At this stage, we may observe that some whisper, and guess could have been exercised by us if some worthy document or circumstance regarding lodging of prior report were either produced for perusal of the trial court or were shown by circumstances of the case, but no worthy and authentic paper, record, or circumstance has been brought forth by the prosecution by the informant. Further, the insurance policy refers to the number of cover not correlating to the same number as that referred in the cover note. Therefore, submission is the time recorded in the cover note is correct. The insured seriously disputes the time of issuance of the insurance policy. Normally, the liability would either be on the insurance company or the insured. After the matter is adjudicated by the tribunal, the person succeeding will have right to recover the balance amount to the extent of success from the other person. The issue raised by the learned counsel for the petitioners that the matter has been decided much after the denotification in 1991 has therefore no substance. It may also be stated that the appellant did not make any clear, sound and positive averment as to which officer of the government, when and in what manner gave the assurance to the appellant or any of his colleague that they would be promoted as lecturers. After considering all the applications, the bid evaluation committee in its meeting on 8/9/2010 accepted the bid of the petitioner for developing and constructing the modern slaughter house. So far as the delay in filing the FIR is concerned, there appears to be substance in what has been stated by PW4. Every human being would not react in the same manner when he sees commission of an offense. A person might be bold enough to catch the offender, or he might run away, and someone might never inform the police. 800 के आसपास शब्द है, एक दो वर्ड कम होंगे. 151 और 152 से बोला गया है और 100 की स्पीड है. 8 मिनट 13 सेकंड में बोला गया जिसमें 5 मिनट का स्टार्टअप टाइम था. तो ये लगभग वही है, एग्जैक्टली 100 होगी लगभग, या फिर 99 होगी एग्जैक्टली, इससे कम नहीं होगी. ये 3P का लीगल मैटर है, 151 और 152 से बोला गया.